If you're looking for the latest news, insight into what it means, and the sharpest opinion, there's only one station in Chicago where you can turn, and it's this one. We're AM 560. The Answer.
Top of the morning, Dan and Amy. So yesterday, the Illinois Supreme Court overturned the conviction of Jussie Smollett. That's a French actor, borrowed from Chappelle. Jussie Smollett, yeah. So I know that probably came as a surprise to some, and people are rightly upset because it just represents sort of more of this a different sort of lawlessness and aspect of the lawlessness in Illinois, which is sort of the politically connected aspect of the lawlessness. Because if you're recalling, there was a lot of intrigue about Michelle Obama's chief of staff, Tina Chen, communicating ex parte with Kim Fox about Jussie Smollett. And then they struck this unholy deal where he gets 15 hours of community service and forfeits $10,000 bond, and we call it a day, which of course led to the special prosecutor being appointed in the form of Dan Webb, and this legal saga that has dragged on now for years.
6 years.
But I got to say, if you're reading the Supreme Court opinion, the state Supreme Court opinion, you know, I really don't put this on the Supreme Court. It is the unholy deal that Kim Fox cut with Jussie Smollett, and she bears the brunt of the responsibility because I think, and we'll talk to a retired Cook County judge about this too, but I think there's a pretty strong argument the court makes that this deal that was entered into, Jussie Smollett held up his end of it.
Right.
That may have been a bad deal, but he held up. But he held up his end. He did the community service. He forfeited the bond. So that's consideration. The specific performance created the reliance. And then for that deal to be obviated by a judge-appointed special prosecutor and to go at him again, I don't think is consistent with relevant case law, and I don't think it's in the interest of justice. Even though it was an unholy deal, the focus shouldn't be on bitching about the Supreme Court. It should be on, I don't know, reminding everyone just how bad Kim Fox has been over the last 8 years. But that's my view.
But it's such an embarrassment. I mean, it made Chicago look we are homophobic, racist. This was MAGA country. And we all know what really happened. And that's what is pissing a lot of people off. We know that he cut a $3,500 check to his friends, the Ascendario brothers, to go to River North in the middle of the night. And here they are reenacting what happened that night to Fox.
So I saw him out the corner of my eye, and I was like, okay, that's him. Let's go. We gotta go get this Empire Yeah, that's him. That's him. Is that him? That's that nigga. And that's when we started yelling the famous slurs he wanted us to yell. Hey, aren't you that Empire Empire nigga? It's MAGA country.
MAGA country. And then they poured bleach on him. They roughed him up a little.
I think we all know what happened. I think we all know what happened. For more on this, we're pleased to be joined by retired Cook County Judge Jimmy Brown. By way of background, he was an assistant Cook County State's attorney for 5 years, criminal defense attorney for 8, and a circuit court judge for 18 years. Former Cook County Judge Jim Brown, thanks for joining us. Appreciate it.
Good morning. It's an honor to be a guest on the best show in all of media.
Well, thank you so much. So your opinion on the Supreme Court's opinion?
Well, Dan and Amy, I want to preface my comments with the caveat that I cast no aspersions towards the Illinois Supreme Court, and I ascribe no nefarious motives to any individual member on the Illinois Supreme Court. With that being said, however, I strongly disagree with the court's reasoning. This decision does very little to instill public confidence in the integrity of the Illinois judicial system, and simply put, the decision allows Smollett to escape justice based on a legal technicality. And what I find so remarkable about the opinion itself is what is actually not in the opinion. There is not one comment in this opinion concerning the quality and the sufficiency and the strength of the evidence, because, in fact, the evidence of Smollett's guilt was overwhelming. There's not one comment about the performance of the trial court judge in this case, because, in fact, he gave Smollett a fair trial. There's not one comment about the Office of Special Prosecutor and Dan Webb and his team because the prosecution was fair, swift, and decisive. Further, there's not one comment about the jury or its verdict. And lastly, there's not one comment or criticism of the Chicago Police Department because I believe, and many believe, that investigation conducted by the police was thorough, professional, and they treated Smollett with the utmost dignity and respect. Now, I can assure you and Amy and all your listeners that if any of the aforementioned had committed any type of misconduct or any error whatsoever, we would be reading about it in that opinion. And this is what I consider to be so distressing about the court's opinion.
Okay, but aren't the court's hands tied a bit because of the deal that was entered into? I know the appellate court upheld the conviction, but just from the state Supreme Court's opinion, Illinois case law establishes it is fundamentally unfair to allow prosecutors to renege on a deal with a defendant when the defendant has relied on the agreement to his detriment. So, what is the response to that?
The response is that the law is miscited, I believe, by the Illinois Supreme Court. On March 26th of 2019, when Smollett went to court, the state nollie-prossed the case. Under Illinois law, and actually under the law throughout the United States, nollie-pross means that the case got suspended. There was no promise by the state whatsoever to never prosecute him again. There was only a promise to suspend the case. The state, under the theory of nollie-pross, has the right to reinstate the case for any reason they choose. And the court did not discuss that adequately, in my opinion.
Well, but the court did say, this nollie prosequi, that we have previously held that nollie pros is entered before jeopardy attaches. The state may re-prosecute the defendant subject to other relevant statutory constitutional defenses. So it's not an absolute. It is essentially the idea that it's so long as there has not been a deal that dispenses with the matter made. And they argue, again, the specific performance, $10,000 bond forfeiture, 15 hours of community service. You may not like the deal, but that was the deal, and he held up his end. So it was in force.
That is a good argument, Dan. However, there is no precedent in Illinois case law that states that the state couldn't reinstate the case. This is the first time ever that the Illinois Supreme Court applied contract principles to a criminal case, offer acceptance and consideration. They had never done that before. There was no precedent for that. This is the first time that the Supreme Court made that type of a ruling.
They sort of conflated the idea of waiving a constitutional right with waiving with the bond forfeiture that the prosecution tried to characterize as voluntary. But he definitely acted in detriment to his defense by the specific performance. So, isn't that essentially an incriminating act that could be used against them, that he committed only under the belief that this deal was in force?
Well, if you note that on March 26th, after Smollett and his attorneys walked out of court and were conducting interviews with the reporters, Smollett's attorneys specifically stated that they had no deal, that the state just chose to dismiss the case. They stated, we have no deal. So there was no detrimental reliance on the part of Smollett. Furthermore, Smollett forfeited $10,000. The restitution, the police overtime, amounted to $120,000. So there was no real agreement, in my opinion.
So is this case over, or we're never going to see the $120,000 that he owes our Chicago Police Department?
Well, the criminal case is over. There still is a pending civil case where the city of Chicago is seeking reimbursement for the police overtime of $120,000. So it's not over from a civil law perspective, but it is over from a criminal law perspective.
What about the trial court? I mean, if this deal was as unholy as I'm describing it, if there were the ethical breaches by Kim Foxx that we both stipulate to, then why was that deal allowed to be consummated?
Well, it's my personal opinion, there's nothing in the record, that he was given special treatment by the Cook County State's Attorney's Office because he was a Hollywood actor and a celebrity. And I would note that during the Office of Special Prosecutor's investigation of this case prior to trial, the State's Attorney's Office, the Cook County State's Attorney's Office, could not produce one example of anyone, any defendant, being given this type of a deal based on those charges, not one person. Meanwhile, they produce evidence, the State's Attorney produced evidence that 5,400 people, defendants, had to go through a deferred prosecution program and report to the court and follow all kinds of conditions and restitution. Smollett was unique. He didn't have to do any of that. He was given preferential treatment. And it was just grossly unfair.
But why did the judge accept the deal?
The judge did not accept the deal. The judge just granted the motion to nollie pros, which only means we're suspending the case. There was no promise by the state on the record that they would not prosecute the case in the future. That's why I believe the Illinois Supreme Court's legal reasoning is incorrect.
Well, I wanted to ask you this because, Judge Brown, because Kim Foxx, I know ethical breaches were made. Well, a lot of people think that in the court of public opinion. But she's now acting like a victim and said, well, just hear what she said, and then I want to get your reaction.
It has always confounded me that we spent this much time, energy, and effort on one single case, which is why I believe wholeheartedly that it was beyond just the case in Mr. Smollett. It was truly an attempt to undermine me. And the work that this office was doing.
What is she saying there?
I emphatically disagree with that statement. There were so many ethical lapses that the Office of Special Prosecutor found during its investigation. For instance, they found that Foxx made 5 false or misleading statements to the public. They found that she did not understand the law of recusal. When an attorney, state's attorney, recuses themselves from a case, they recuse the whole office. Foxx thought that by recusing, she only recused herself and not the remainder of the office. She was completely wrong on the law. The case just has mud all over it, in my legal opinion.
And the argument that the appellate court made. What did they say in terms of addressing this sort of fundamental issue about whether there was detrimental reliance by Smollett on the deal?
Well, again, they said that the state went on the record on March 26th of 2019 and nollie prossed the case, which does not preclude them from reinstating or reindicting that case. Furthermore, the appellate court stated that there was no precedent to apply contract principles to a criminal case. Under Illinois case law, it had never been done before. And so, in fact, there was no detrimental reliance on behalf of Smollett. Just forfeiting the bond in doing 15 hours of community service did not amount to detrimental reliance.
What about their use of the Supreme Court of Pennsylvania's decision in the Cosby case? They make the analogy and they write from Cosby, it cannot be gainsaid that society holds a strong interest in the prosecution of crimes. It is also true that no such interest, however important, can eclipse society's interest in ensuring that the constitutional rights of people are vindicated. Society's interest in prosecution does not displace the remedy due to constitutionally aggrieved persons. They basically took up the argument that the Pennsylvania Supreme Court made in Cosby and applied it here.
Well, it's an interesting argument, too, but the law in Illinois is clear. Illinois is not bound by another jurisdiction's precedent.
Right.
And they're free to ignore it or accept it. Obviously, the Illinois Supreme Court accepted it, but the appellate court did not. So this case is unique to Illinois, and I agreed with the appellate court in this case that they did not need to abide by that precedent.
But fundamentally, I mean, the blame here rests mostly with Kim Foxx.
The blame relies 100% with Kim Foxx. Again, because Smollett was given such preferential treatment, it was inherently and grossly unfair to other defendants charged with those kinds of cases. It's obvious that they were starstruck by his celebrity, and also there's evidence of people calling the state's attorney on his behalf, and it just has so much taint, this case, that it's just a sordid chapter in Illinois history.
I wanted to get your opinion on one other matter. We discussed a bit yesterday, this judge, Cook County Judge Thomas Nowinski, who is under fire for releasing an individual who on a domestic violence charge, and then he went back and killed his wife, allegedly. There's a hue and cry in politicians. Susanna Mendoza, who wants to run for mayor, he needs to step down immediately. The judge wrong in that case, or his hands were tied by the Safety Act?
Well, I think there's a lot of mitigation that you have to afford Judge Nowinski, because, in fact, he is kind of bound by the Safety Act, which I would refer to as the Unsafety Act. There's so much pressure on the pretrial court judges to release people into the community. It's just very difficult for them to hold people over. They want the powers that be want the Cook County Jail empty, so they err on the side of releasing people because we have cashless bail. So there's just a lot of pressure on those judges. Obviously, in hindsight, his decision is wrong. Human behavior is very unpredictable. The decision was wrong, but I mean, there's a lot of mitigation there. He's under such great pressure to release.
Yeah, but this is the second time this year he's let a domestic violence suspect go that has resulted in a murder. So I think
that is true. But, in the domestic violence, and I served in the domestic violence division when I was on the bench, the human behavior is so unpredictable, especially when there's sudden intense passion between people that love one another.
Jimmy, we got to
predict.
Yeah, we got to leave it there, but I appreciate it. Retired Cook County Judge Jimmy Brown, thanks so much for joining us. Appreciate your insights.
Thank you.
And we'd love to have you back. And he joined us on our turnkey.pro answer line. It is now 7 a.m. WIND Chicago.
Matt Gaetz is out. Pam Bondi is in. I'm Dave Anthony, Fox News. She's President-elect Trump's new nominee for U.S. Attorney General, hours after Gaetz withdrew. Bondi used to be Florida's Attorney General and was a Trump attorney in his first impeachment case. Fox's Alexis McAdams reports from West Palm Beach.
This is one of the main reasons that Bondi was floated and picked pretty quickly, according to sources, is because she says the DOJ needs to be held accountable. Listen.